In Texas, the focus of the court when dealing with child custody is to award parents shared custody whenever possible. This allows children to develop and maintain meaningful relationships with both parents. There are times when alternative custody arrangements may be in the best interests of the child. One of those alternative arrangements is the granting of conservatorship to a child's grandparents. If you're wondering about the reasons grandparents can file for custody, keep watching. We're going to share everything you need to know about grandparents' legal rights to custody in Texas. Filing for custody. The law favors awarding custody to a child's parents. For grandparents or any other relative to obtain conservatorship in Texas, they must prove there's a need for them to assume this role. One way of doing this is to show the court the child has been under your custody or control for a minimum of 6 months prior to filing your case. Parents who are agreeable to granting custody of their child to grandparents may sign a Texas Minor Child Power of Attorney form. This document awards temporary guardianship to the grandparents. The power of attorney allows them to make all decisions regarding the child's care. The problem is this is a temporary arrangement that may be revoked by the parents at any time. The power of attorney is a solid document if there's a reason for temporary custody that's not related to the child's environment being unsafe. If there is reason to question the safety of the child under the custody of their parents, a court order holds more standing. Whenever the custody of a child comes before the court, the best interest of the child is always the primary consideration of the court pursuant to Texas Family Code 153.002. Managing conservatorship. Grandparents may seek a managing conservatorship through the court. If the court grants conservatorship, the grandparents have full legal control over the minor children. This includes determining where the child lives, attends schools, religious instruction, and medical decisions. There are 2 instances in which a grandparent may file for conservatorship. The first is if there is evidence the child's current living environment is detrimental to the child's emotional or physical well-being. The other reason grandparents may seek conservatorship is when the parents of the child or the child's custodian agree that granting the grandparents conservatorship is in the best interests of the child. Possessory conservatorship. If someone has a child custody case in process, grandparents may file for possessory conservatorship. This allows the grandparent to make important decisions regarding the child. It also provides the grandparent with visitation rights. The law only allows grandparents to intervene if they have a history of substantial contact with their grandchild. There must also be evidence that the current living conditions may cause significant physical or emotional harm to the child. You now know the reasons grandparents can file for custody. If you believe a change of custody is in the best interests of your grandchild, the law offices of Scott M. Brown and Associates can help. We have experience in all family law matters and can help you obtain a result that's in the best interests of your grandchild. Our main office in Angleton assists clients throughout the Houston area. We also have offices in Pearland and Webster. Please contact us by phone or use our online email form to schedule a consultation. We look forward to hearing from you. Thanks for watching, and if you enjoyed this video, be sure to give it a like, comment, and subscribe.